people. Thank you, God, for loving us. Thank you for caring and protecting us. And we continue to look to you for even more mercies. In the name of Jesus, amen.
Thank you. Thank you. Apologies for absence. Do you have apologies? Ms. Nito? Okay, please note. Just want to welcome everyone here this afternoon. Members, I'm so happy to see that we have a quorum. More than a quorum. That's excellent. And both houses represented. Isn't that wonderful? That's great. That underscores how seriously we take this matter of sexual harassment. So I just want to welcome you all here and to go straight into the matters at hand. I'm going to ask if everyone has had a chance to read the minutes and to have confirmation of the minutes. So, ask for confirmation. Confirmed by Mr. Whittle, and
I can confirm.
Seconded by?
Second.
Okay. Right. All right, now I'll ask for matters arising from the minutes.
Chair, can I, in
Yes,
relation,
please go ahead, Senator.
in relation to matters arising from the minutes, 5.2.3, the public notice and submissions of the bill. So there was a listing that we had suggested. Can we confirm how many of that list would have responded?
I understand only 5%. And we had placed 2 notices. We placed one just before Christmas, and we are to decide when we would do the next notice. But we placed 1 notice in print, and of this list, maybe they were all written to, and only about 5% responded.
Chair, in terms of who may have responded, I'm wondering whether the university is one such group. And also, if the university has responded, are we going to get a voice from the Students' Guild? Because I think that will be somewhat relevant to ensure that we get a voice, a feedback from the Students' Guild.
Members, I'm being advised here that a notice was sent out to us indicating the responses that we had. No one acknowledged the correspondence. But I'm to understand that the law school, for example, indicated that they would not, at this time, be able to make a presentation but they will submit. We have not written to the Students' Guild, and we will do so.
I recall, sorry, Chair. I recall responding to one that had indicated a request for an extension, and I had given my approval to that extension. But the concern I want to raise is that given the fact that this is a critical piece of legislation, and looking on the list, there are some institutions or organizations outlined on this list that I believe it would have been very important for them to even add their voice, recommendations, or concerns. And whilst the stipulation is to provide notice, I'm just asking whether or not we can at least give another nudge in that regard.
We will place more public notices in the paper, and we should do some social media. I think we had discussed that we should go beyond the traditional way of advising the public. So far, we have only placed one notice, so we still have a lot more to do in sensitizing the public and getting responses. So we will step it up at this time. We'll do so. The Ministry of Labor and Social Security, for example, they're here to make a presentation, and they were among the list of ministries and entities that were written to. So they are here. Jamaica AIDS Support, they will be making a presentation as well, and Jamaica Lands. The Ministry of Tourism was scheduled to make a presentation, but they are unable to do so today, as I understand some pressing matters came up, and they're not able to be present. So we do have at least 3 presentations today, and we will ensure that our public relations and communication effort will be intensified, so that the next meeting we will have greater response. So at this time, I would want us to go directly into presentations and discussions. So I will ask the Ministry of Labor to proceed with your presentation. You have been advised that you have 15 minutes. If you're not finished in 15 minutes, we can determine at that point how much additional time you will be given. Please identify yourself just before your presentation. Thank you.
Good
We have some seats up here, empty seats up here. Please come up. Seems like everybody's afraid of the front row up here.
Yes, good afternoon. My name is Camille Bennett Campbell, Director Legal Services in the Ministry, and I'm supported by Mrs. Janita Smichael, Senior Legal Officer. So the Ministry supports and lauds the work of the Ministry of Gender, Entertainment and Sports and the Bureau of Gender Affairs for undertaking the work necessary to table this long-awaited bill. This bill will fill an important lacuna in the legislative framework, by protecting workers who are susceptible to sexual harassment. I will move on to our specific comments. In relation to the definition of worker, we support the wider definition of the term worker. It incorporates employees, domestic workers, apprentices, and persons engaged under a contract for services. We believe this wider protection and coverage is essential. However, in relation to Clause 2, we note that you have used the term employer, but in Clause 2, in Clause 2, a worker is defined as a person who carries out work in any capacity for a person conducting a business or undertaking. However, we note that you have used really the term employer as opposed to person conducting a business or undertaking in the legislation. So we believe this may just be an error and ask for it to be visited from a policy standpoint, because we believe the intent here is to use the term employer instead of person conducting a business or undertaking. In relation to Clause 4.1, we were querying why this clause is subject to subsection 4. We can double check if it should be subject, if it's more relating to Clause 4.3f. In relation to Clause 4.3c, we are not certain what is meant by the term disciplinary measures in the bill. Is it the same as disciplinary action such as suspension, demotion, dismissal? We know that the term disciplinary action is used in Clause 3.4f.
Sorry, Chair. Sorry. Could you, Mrs. Bennicam, just go a little slower for us? We're trying to follow as greatly as possible, especially when you point to a particular area. It would be good for us to at least have line of sight of that particular area so we can connect with you as greatly as possible.
So should I go back from number 2? Okay. So 4.1, it says, subject to subsection for every employer. And it speaks about giving a policy statement in writing concerning the prevention of sexual harassment in the business or undertaking, and taking steps to bring the policy statement to the attention of the employers. 4.4 now says, an employer or a person in charge of an institution who discloses any information related to a complaint or the circumstance of a complaint in contravention of 3F shall be liable for such disclosure. And a complainant who is aggrieved by such disclosure may make a complaint in respect of thereof to the tribunal. So, we are not sure why 4.4 is linked to 4.1 in particular. We know that it is more closely linked to Clause 4.3f. I'm confirming that I'm reading from the bill before you. I have Sexual Harassment Act 2019. That was on the House of Parliament website. Okay. All right. In relation to Clause 4.3c, it refers to the term a statement to the effect that disciplinary measures as are appropriate shall be taken against any person under the direction of the employer. So we were querying if disciplinary measures is the same as disciplinary action in Clause 3.4f. But the point we were making is that we haven't seen any mention of due process in this mechanism that is to be incorporated in the statement before taking such measures or action. So we're just pointing to the Labor Relations Code that gives some amount of guidance, and the Labor Relations and Industrial Disputes Act. In relation to clause 7.6, we query why both the terms complaint or claim have been used here. We note that in clause 5.2 and clause 6.2 refers to a complaint being made to the tribunal. Clause 8.3 refers to institution of proceedings by way of a claim. Clause 13 suggests that a complaint is made by a worker and a claim is instituted by a student, a resident, a ward, an inmate, a patient. So in terms of consistency in language, I am not sure if there was meant to be a difference between a complaint and a claim. So just ask for that to be revisited. Okay. All right, clauses 12 and 14. We note there is a chairperson. We are wondering if you should not also have a deputy chairperson appointed. Because if the chairperson has to be a part of every channel which hears matters, then you may face prolonged delays. The deputy chairperson could also be in a position to chair a panel. I relate this in the context of the Industrial Disputes Tribunal because you have the chairperson, you have the deputy chair. A panel is made up of 3 persons. The chair or the deputy chair would be the persons leading any panel. So we're querying if you only have the chairperson, will not restrict you if the chairperson has to be on every panel that you have. Mm-hmm.
Looking at that section 12.2, wouldn't that satisfy? I'm just curious. In the case of absence or inability of the chairperson to act at any sitting of the tribunal, the members of the tribunal present at the meeting shall elect one of their number to act as the chairperson at that sitting. Would that suffice or you needed?
Because it says absence or inability to act, I think it's a state of situation where for some reason illness or so, the chairperson may not be able to act. But for regular panels now, hearing a matter, you have 3 persons hearing in each matter. And I think I've seen from here that the chairperson is to be on the panel. So for each matter, would you want to be using this procedure to say absence or inability of the chairperson? Or would you just want to have a deputy chairperson in place to begin with who would always be there to actually be on the panel? Because I also raise a point because normally, I ask a point because who breaks the deadlock if a panel of 3 hears the matter? Normally it's the chairperson who would break the panel or the deputy chair.
Chair, you also, and when the ministry cite reference to the tribunal, the Industrial Disputes Tribunal, it assumes that there may be a plethora of disputes appearing before the tribunal. And so suppose you have more than one dispute at the same time. You would need a deputy chair, and that is why the IDT has panels. It has a chair that is the overall leader, but there are deputy chairs who also so happen to chair panels hearing disputes. So that is a context in which I believe the ministry is citing.
And I do agree. I think we would definitely have to look at that. It's similar also to how the JADCO tribunal, disciplinary tribunal, in fact, they have 2 deputy chairs. In addition to the chair, 2 deputy chairs. So we would have to look at that.
Okay. All right, going to clause 14.2.
So, Madam Chair.
Go ahead,
No, I
Member
was just checking
Whittle.
about if you're going ahead with that, what about the appointment of the deputy chair?
No,
It's still, or you're going to look at it?
Yes, we're going to look at it. And of course, the presentations here, we're going to do a matrix of all the recommendations made. But most definitely, I think the tribunal would require a deputy chair, if not two deputy chairs, as done in other tribunals, some of the other tribunals, because we're speaking of a at least based on the act here, we're talking about what, 12 persons? And we would have to maybe have several panels going at the same time, and not just in Kingston, but across the island. So, you know, we really have to look at that carefully and determine.
And that will be done as is here by the minister, the deputy, the position of the deputy.
Yeah, but based on the recommendations that will come and we do the matrix, then we can go now and look at the legislation and make the necessary adjustments. Good. Yeah, continue, please. Thank you.
Yes, and I'm still at the tribunal. 14.2 says at least one member appointed pursuant to subsection 1 shall be a female, and another member so appointed shall be an attorney at law and the chairperson of the panel. So it suggests that the chairperson would be on the panel that hears a particular complaint. So we were querying, it's not clear that though if the clause is stated that that the chairperson of the panel, who is an attorney at law, right, is the chairperson. Oh, it is not clear if the clause is stating that another member is to be the chairperson who is an attorney at law. We suggest that you revisit this clause to ensure that the meaning is clear. So is it that it should be an attorney at law and the chairperson, or is it that there are two persons, the attorney at law and the chairperson who is also an attorney at law? We suggest if the former is the intent, that is a female, an attorney at law and the chairperson, you may have the presence of two attorneys at law on each panel, which will reduce the role of the persons who are selected under clauses 11.1b and clauses 11.1c, unless these persons are mostly female. So I just asked you to just have a look at the constitution of the panel, just to make sure that you have enough representation of the persons for the different matters. And as the Ministry of Labour, we are saying it is important that persons qualified in labour relations form a part of the panel which hears complaints in relation to workers. Clause 13.1b. I think I was not seeing a 4.1f. So I believe this may be 4.3f or clause 4.4 that can be reviewed. Clause 17. It says the minister may appoint any person to act in the place of the chairperson or any other member of the tribunal in the case of the absence, inability, or refusal of the chairperson to act. I'm not sure if there was a mechanism there as to although it starts by saying the chairperson or any other member of the tribunal, the latter part of the clause only speaks to the chairperson. We also question in relation to appoint any person to act. Is it that the persons will have to meet no specific criteria to be eligible to act? Because it does say any person. Should it have to be from the same class from which you were appointed in the panel to begin with? So that could be reviewed. In relation to clause 20, infirmity of body or mind. We're just asking you to be mindful of the Disabilities Act when considering the language, because, you know, it's not every type of disability, mental or physical, that would make you unable to act. So I'm not sure how the words infirmity of body or mind would be construed. And so just be mindful of the Disabilities Act also, because it does say there should be no discrimination, and it speaks about employment, provisions in relation to employment. And the Mental Health Act. In relation to clause 25, it speaks to making of complaints, and it sets out the circumstances and the relevant clauses that apply. We ask you to reconcile with clause 13, though, which sets out jurisdiction. Sections 3.1 and 3.2 are not actually referenced in clause 13, which is the jurisdiction of the tribunal to hear and determine complaints, whereas it is referenced in 25, and I think it should be a part of the jurisdiction. So I think it may just be an omission, because the other clauses are there. Clause 29.3b, that was just a minor error. I was seeing lake instead of take, but my eyesight is not great, so I won't swear for that one. All right, this is just number 11. It's just general guidance. Just looking at our experience with the Industrial Disputes Tribunal, we asked you to consider these provisions. What will happen if one or more of the members of the panel dies, becomes incapacitated?
You refer a while ago to a number 11. Mm-hmm. Is it number 11 on your document?
My document.
To which we don't have.
Oh.
It's in? Oh, sorry.
Just tea for me now. Not sorry. Can proceed. What will happen if one or more of the members of the panel dies, becomes incapacitated, or ceases to be a member of the tribunal after the panel has commenced hearing a complaint, but before an award or decision has been handed down? That is a real situation we have faced with the Industrial Disputes Tribunal, where the LRIDA, Labor Relations and Industrial Disputes Act, says the proceeding should begin de novo. You should choose somebody else to replace the person who has died or is incapacitated. The proceeding should begin de novo unless it is that the parties all agree for you to continue. But unfortunately, the LRIDA only dealt with what happens if one person dies. It never dealt with it if another one dies. So I'm asking you not to fall into that same trap, just to think about it, because we have had to face that as a real situation. I did not see it on the face of this. And how will a panel make a decision after hearing a complaint? Should it be by voting? Is it by the majority of the members? What happens if there's a deadlock? Should the chairperson or the person chairing make a decision if there's a deadlock? We ask you to consider those situations, because you will not, if you're having a panel of 3, you will not always have agreement between all the persons, and you don't want to actually not end up with an award because of that. Asking, will the Arbitration Act apply to the proceedings of the tribunal? Because this is similar to arbitration, you should consider whether or not it applies. In relation to the Labor Relations and Industrial Dispute Act, the Arbitration Act does not apply to proceedings of the tribunal, but this, you would have to make that determination here, or as to whether you want to say that or don't say that. All right, my last point. Clause 34(1)(b)(3). Okay. After conducting a hearing, the tribunal may dismiss the complainant, or it can make several awards as outlined in B, including a direction that the respondent should employ or re-employ the complainant. I believe the employ is used because of the prospective employee, but we are just questioning though, because the foundation of the employment would be the employment contract. Can you compel persons who have not entered into a contract to begin with to actually enter into a contract? And in relation to termination, we have done it in the context that you were in a contractual relationship, and but for the action of the employer, the wrongful action, the relationship would have continued. We have to, this would be a new era for us. We have to tread carefully as to how we approach this in terms of, should it be compensation, or can it be that you can compel an employer to actually employ a person, that the tribunal can have that power. In relation...
Sorry, could it be to separate the, rather than have employ or re-employ? We can understand re-employ, because if an issue arose and disciplinary action was taken and it led to a dismissal, we can understand. But would you suggest, therefore, that you could treat the employ in a different area and don't tie it together with re-employ?
Yes, I would suggest that would be the case. And in relation to re-employ, I just want you to be, well, for us to be mindful of what we mean by re-employ. Because, you know, under LRID we use reinstate, and you know there's also re-engage. Now, I've seen that in some countries re-employ means reinstatement and re-engagement. So I'm not sure if it's something we need to look a little carefully as to what we mean by the term re-employ. Because, I don't know if you want into the tribunal to have to interpret it. Because reinstatement is putting you back in your former position. Re-engagement is basically putting you in a similar position. It may not be the exact post that you were taken out of. It may not be possible. But we see the room for re-engagement and the re-employment if it covers both. But you may have to give some guidelines if you're using re-engagement as to what is re-engagement. Is it on the same terms? There's jurisprudence out there that can be guided. And I say this in the context that this is similar, not the re-employ. We are using reinstate and re-engagement in the Occupational Safety and Health Bill now, trying to get the two in, but you know, you have to consider what it means and what does re-employ mean in this jurisdiction.
Well, you know, Chair, you know, there's a case now hanging outside around a particular type of suspension at a particular hotel where the interface of re-engagement as opposed to reinstatement was used. Maybe what we need to do is to determine which one of the terms we're going to use and include that in the definition clause.
Yes, noted. Go ahead, Mrs. Bennett Campbell.
And, well, I think, one thing I had forgotten to raise on the paper, but it occurred to me, because it occurs to me that because this is covering dismissal and certain other actions, I don't know if it has dealt with the fact that some of these matters could actually go to the Industrial Disputes Tribunal under the Labor Relations and Industrial Disputes Act. A worker who has been sexually harassed, dismissed for that reason, could be claiming that they have been unjustifiably dismissed. Is there going to be any protection from persons seeking double redress for the same kind of action against the employer? Because basically it could be that that person could be going to the Industrial Disputes Tribunal if it's an industrial dispute. So dismissal, suspension. And I didn't see anything on the face of the bill that kind of tried to contemplate that dual jurisdiction that might still exist.
Chair, the bill, and I hope I'm not taking any time out of your 15 minutes.
No, you don't have to worry about that.
But Chair, the bill assumes that it is not limited to just the workplace, but the schools, the institutions. So maybe the distinction in terms of where you want to carry the dispute, if you want to carry it from the workplace to the Industrial Disputes Tribunal, or those relating to other institutions to this particular tribunal. But then again, it also assumes that the Industrial Disputes Tribunal is already overburdened.
Well, that is why in the first place this was not referred to the Ministry of Labor and treated under the Ministry of Labor, that an independent tribunal was being established, because in fact the Ministry of Labor had prepared a very comprehensive argument as to why it could not address the sexual harassment legislation.
So what we might suggest is maybe you could put in provisions to prevent double awards for the same kind of action, that if you have utilized this provision already, that you're not getting double. There are ways to actually deal with it, so you're not getting double awards for the same kind of action. So you could consider that. OSHA, Occupation Safety and Health will try to do it, so you can have a look, but kind of fix it, because we're still going for our clause by clause, just to ensure that that is tidier. And the last thing, clause 38.1, we noticed that there reference to adverse action, but we're not certain what, I don't know if it is that you should consider defining what is an adverse action for the basis of this bill. Our comments will be of assistance. That was it. I hope I within my time.
Well, Mrs. Bennett Campbell, you have done an excellent job in presenting the position of the Ministry of Labor. Inviting members who may want to comment on your presentation.
I just want to ask, so today the Ministry of Labor is making their presentation, but I just want to ask if the Ministry of Labor will be present throughout these sittings, especially when we're going through the clause by clause, because we might have the opportunity to in detail to get the guidance from the Ministry of Labor, since some of these areas are work related in nature. So whilst I'm not seeking to detain the ministry, I would strongly encourage their presence throughout these proceedings.
Thank you, Member. I will certainly make that request of the Ministry of Labor and other relevant ministries and agencies who we think their presence would be important when we're going through the legislation clause by clause. Thank you so much for your presentation, Ms. Bennett Campbell. Thank you. If there are no more questions in relation to that presentation, we could move on. Sure.
When adverse action, I mean, isn't it sort of a duplication, you could say, to any action on the ground, because the action you're contemplating is there. And the idea of the adverse is that what is contemplated in A and B are really adverse. So, you know, I don't see the need to define adverse action. Adverse means what is there, A and B. We look at it, but it seems to me that it's defined by saying the adverse is what is contemplated in A and B.
What I was considering is it's adverse action because you have made a complaint under the Act. Is the adverse action the same as a disciplinary action, for example? Because it's adverse action on the ground of any one of the following. Mm-hmm. So because you have made a complaint under this Act, you have been subjected to some form of adverse action. That's how I was reading it. Right. So it's any form of adverse action that is what you're considering then.
Yeah,
which would be suspension, any kind of action at all.
But I wouldn't see the need to define adverse
Well,
action.
I do that because of I am in another joint select committee where I have something similar and I have been having to define it. So I'm just coming from the experience I am getting because we have a similar provision with a term which I've had to be defining.
Okay.
And I think because it creates an offense, Minister, it might be better for us to be clearer about what it can't.
Or just remove adverse, an action, rather than saying it's clear that it is when what happens under A and B is affecting. I mean, you can't have a conviction unless something wrong, a wrongdoing occurs because of that.
Are you suggesting that the term adverse can lead to some level of subjectivity in terms of you have to quantify the extent to which it's adverse?
No, right. The adverse basically mean there has been something affecting that other person.
Yes.
That is in a negative way. So you know, it's not if it affects the person in a positive way, there can be no criminal conviction. So that's why you say adverse, which means in a negative way. Because if the person benefits from whatever occurs, there won't be any need for criminal liability. But it's something we can look at. But,
Something we will look at.
Mrs. Bennett Campbell, you did mention in 4.3c the statement to the effect that disciplinary measures, and you're quite right when you indicated that it has to be spelled out in terms of the disciplinary procedures and guidelines so that persons would know their scope of permissiveness and what you're going to be charged against and the various penalties.
Right. So we.
Madam Chair.
Yes, go ahead.
No, I just want to say in relation to the issue about whether or not there should be a definition for adverse action. I believe that the trend these days is to make the language of our law such that the average, I hate that word, I don't know what to say, the man in the street, right, the average Joe or Jane, would be clear on what is meant. And so whenever a question arises, I would tend to rule in favor of the action that makes it clearer for the man in the street. And I believe that that is something that we need to be conscious of because the laws that have been bequeathed to us are not always written in a language that is easily understood. That we're discussing it.
Positive. Right. But it really meant adverse, really something that has affected the person detrimentally. You see, so. But I'm saying this, I don't know if we need to define it, but we will examine it.
Yeah, but we can examine it. And the comment,
Sure.
Mrs. Bromberg, about the legislation that we need to make the language clear, and we may have to do simplified version of the legislation and make those available to, break it down. The lawyers are happy with the way it is, but the ordinary person needs to understand. So that's something, and particularly in the case of this sexual harassment bill, it's going to have to be very clear to everyone because of the nuances that that comes with this bill. All right, thank you. So we will now take a presentation from Lands, from Jamaica Lands, and it's Christoph Simpson. Yes. All right.
All right. Give me a second. Let's go to the first page. Oh. This Can you just move this? Because
Christoph, you may want to explain what is
submission.
Jamaica Lands?
Oh,
Because I see some members looking a little puzzled.
this is the second time, and I think the last time during the or submission on the Sexual Offences Act, Floyd Green was explaining to you directly. So what we are is a pre-party formation, essentially. We're not a political party yet, but internally we have structures similar to parties. We are building a network of political clubs and non-political community organizations, and at some point in the future considering forming a far-left party in Jamaica.
All right, please proceed with your presentation.
All right. So yeah, the submission that we have here is a product of multiple meetings that took place across our members and observers. There are over 130 of us. Some of us are UE students. I'm not a UE student, but some of our members are UE students, and everybody in this movement is below 30, I can assure you. Some are even below 20. So we read both the 2015 and 2019 drafts of this bill, and we think it's a progressive step. The first thing somebody thinks about in hearing sexual harassment, especially in Jamaica, is that we're going to address street harassment. But we discussed and understood that legislation really couldn't do something right there, right now. So we appreciate that this is looking at the dynamic between employers and employees, as well as landlords and tenants. So I'll begin. We had 5 main areas of concern, though. So the first one is in the first draft that we read, which was the 2015 one, there was some confusion because we were imagining a case of, say, somebody who is seeking employment being denied because they're not willing to offer sexual favors to the potential employer. That version of the bill made reference to potential employer and potential employee. And there was some confusion because we didn't know where the person would take the complaint, because when we read where they'd take the complaint, we couldn't determine whether it was the court or the Industrial Disputes Tribunal, because that version of the bill had both. This version of the bill now has only the Industrial Disputes Tribunal as opposed to the court. We wanted clarification on why it would be the Industrial Disputes Tribunal that would be handling cases involving people who aren't workers. I understand the definition of workers in this bill is broad to capture like students and interns and so on, but is it appropriate for the Industrial Disputes Tribunal to be handling cases of tenants, residents of residential facilities, which would include wards in children's homes and so on, inmates in prisons, patients of hospitals, or members of particular institutions? I was wondering if the Industrial Dispute Tribunal would be appropriate to handle those things. Some persons may see it as taking this less seriously than if it was being handled directly by the court. So we wanted to know why it would be the Industrial Disputes Tribunal. At the end of the presentation, we'd of course ask you to tell us why it would be the Industrial Disputes Tribunal that is handling all these cases. We don't know how appropriate it is to handle all of these cases. The second main concern, give me a second.
Yes, I think just before I take you, Senator,
Yeah.
Miss Georgette Grant would like to make a comment. She's the attorney in the Ministry of Culture, Gender, Entertainment and Sport, and she would want to respond here.
I just wanted to say, it's Mr. Simpson, right?
Yeah.
I just wanted to say that it's a sexual harassment tribunal. A special tribunal has been created.
Yes.
So in the 2015 version that you referenced, in that version, there was a tribunal that should operate under the Industrial Disputes Tribunal, which is no longer the case in the 2019 iteration. So I just wanted to make that.
So it's no longer the Sexual Harassment Division of the Industrial
No,
Disputes
it's
Tribunal.
not.
It's a tribunal to itself, separate
Yes.
from the IDT.
Yes.
Okay, thanks for that clarification.
I would just like to repeat that the
yes, right here. Okay. constituted under Part B.
Part 5 actually speaks to the tribunal and how it is constituted.
Oh, well, yes, we saw.
Just to make it clear,
yes,
that the 2015 draft bill was withdrawn.
Yes.
The the Ministry of Labor made a strong case that this bill could not be treated or addressed under the industrial tribunal.
Oh, okay.
And it was very clear. The policy itself, prior to the 2015 bill being drafted, had clearly stated that an independent tribunal that treats with sexual harassment is what should be established. So it will not be treated under the Ministry of Labor, under the dispute tribunal, right? Industrial dispute tribunal. And beyond this, if someone wants to go to court, you're free to go to court. If you are not satisfied with the ruling of the tribunal.
Okay, perfect. Thanks for that clarification. Because what we... It's not to exclude the court, but...
You want to say something?
No, as in we weren't thinking...
All right, please continue with your presentation. And then
yeah, so thanks for that clarification. We had thought it meant what we read in the previous, which was the sexual harassment division of the IDT. So thanks for that clarification. The second thing, it would be the second and third thing is, in general, this seems like the main point of this, you protecting workers from employers and, well, workers from other workers, also tenants from landlords. We don't think there's like sufficient protection for workers by clients or clients by workers, which is, I think, also a concern. Unless I'm wrong again, is there sufficient protection for clients by workers? Because to us, we didn't get an impression from reading. I'm not talking like clients who hire a contracted worker. I mean like there was somebody that works at UE that even made a tweet. They visited Starbucks and they said something. It got a lot of backlash because it was considered sexual harassment of the worker there. How would a case like that be handled, or is that provided for in the bill?
So if you look at the definition of the worker on page 4, D, an employee of a person or a subcontractor, or C, a person engaged under a contract for service or a subcontractor of that person.
Yes.
So that was seeking to broaden the boundaries.
But does that cover somebody working as a cashier in a supermarket and a random customer walking into the supermarket and harassing that cashier?
Oh.
Yeah, so
you were
that's...
first speaking about, if I understood, you were first speaking about a worker or somebody who supports a worker. But now you're speaking about a customer.
Yeah. No, that's what I said by client. So I did clarify that when I'm referring to client, I'm not referring to a direct client of a contractor. So that's why I brought in the word contractor, because I do recognize that the definition of worker is broad. We said in submission as well that it includes contract workers, students, trainees, and so on. So we would like to see protection for workers from customers and clients. It would still be the employer's responsibility to create that environment of protection. So we have it here. So if you look at 3.3, that's on page 7 of the document. So we said section 4.1a mandates that every employer adopts policies concerning the prevention of sexual harassment in the business, and section 4.3b1 or 4.3bi states that workers are entitled to an environment that is free of sexual harassment. But we don't see like any hard provisions for serious actions to be taken against clients who may harass workers. And the most a business could do is withdraw its services from a customer or client, but there is no explicit provision for a worker to take action against an employer who refuses to do this. even with reading that the law mandates that every employer adopts policies concerning the prevention of sexual harassment in the business.
You can see the limitation of what you're asking, though. You take, for instance, a supermarket, as you quite rightly put it, and you have a nice cashier there, and customers come and make overpass at the cashier. What can the employer do? Put up a sign to say don't harass the cashier?
No.
No, I mean...
Mr. Chuck, no, but the thing is, this is the angle I'm looking at it from.
Yes.
The worker, if the worker is supposed to retaliate to an instance like that,
yes,
by saying something that somebody may consider rude, it is more likely that the employer is going to take action against that worker than against that person that harassed the worker, and that's the source of our concern.
You see, I can see, and we need to think that out. Is it the employer's fault?
It's not the employer's fault, but unless the state is going to step in and actually do something, take responsibility there, we could say that the employer would do something. So in certain workplaces, you would have some employers that are closer to their workers and would step in and say, no, please don't speak to my staff like that. Something at least like that.
But you have all these problems in the workplace. Here hostesses, waitresses.
They don't call them that again.
What do you call them?
They're cabin crew.
Cabin crew.
Flight attendants.
No problem.
Yes, and it's going to be something prevalent in the hotel industry
waitresses
as well.
and,
yes, but that's the point of us sitting here to propose these things, because we want to end these problems. Section 3 point, is it 3 point? Give us 1 second. Yes, so section 3.6, we do address the entertainment industry. So we are aware these things are happening, and that is why we're saying this. There was a report in the newspaper that hotel staff are fed up with sexual harassment by unruly guests. That is a problem. Now, to say, oh, this is doing too much, no, these people need to be protected from sexual harassment.
So the fact that he has gone there and being a representative of workers in that particular industry, complaints have come far and wide about guests coming to properties where they come here not only for sand and sea and rum and the sun, but the other S, because they believe the other S is hanging here.
And that they're entitled to it.
Are available at their call, at their pleasure. And so and this is where now, where institutions and organizations have to establish a policy, and the policy treats with that. But outside of the policy, what Mr. Simpson is suggesting is there has to be a scope of remedy in the event that occurs. Because can you assume, Minister, that nice cashier that you speak about, that a customer constantly comes in and harasses that cashier to her displeasure, you might find that she's going to get fed up and leave the liquor work.
Or she might react and get
she might
fired.
react in a particular way where the employer views it that, the customer comes first, and the customer is always right. So in this case, this is what the level of probity that we're doing here that is going to expose these scenarios for us to reflect now and identify ways as to how we can treat it. So let us not assume that the exposure to harassment is limited to between co-workers or the employer or a supervisor, but someone who just come to conduct business within the organization.
I want to support what Mr. Simpson is saying. I know of an actual instance where a particular hostess, it's a very high-class restaurant, and every time the guests come there, she's constantly harassed. She has protested to her employer, who, because these people have so much money, just shrugs it off. And this is revolutionary legislation. It is going to break our cultural norms. So we as legislators have to prepare to go far beyond what it is that is considered acceptable. We have to create new norms.
Extremely important. Yes, Mrs.
Yes,
Brownberg.
yes, Minister. I also wanted to support the comments, the arguments being put forward by Mr. Simpson. I can just imagine that because we are breaking norms, that there would be some employers who would be of the opinion that a nice cashier that is there, that the client coming in is at liberty to do whatever. And I believe that specifically because those are exactly the kinds of things that we are trying to prevent and to reorient and have a shift in how persons are seen, that we have to make sure that that is specific. So in so far as we need to ensure that there is a class that specifically deals with that kind of relationship between worker and client, client and worker, I believe it is absolutely essential that that be there.
Excellent.
I
Go
think
ahead,
it is going to be
Mr.
difficult to implicate the.
Pardon?
It is going to be difficult to implicate the employer because this is an issue between two persons. That's the customer and the employee. How are you going to implicate the employer who might be living in the States?
All right.
The challenge I have, though, with my friend is that
It's going to be difficult.
I can't agree with you because if you think about it, the employer does have a responsibility to create a particular environment for the employee. And if a particular advance is made to the employee, which he finds unwelcome, he or she finds unwelcome and reports it to the employer, then the employer should be bound to ensure he takes sufficient action to prevent such a situation from occurring. And should he fail to do that, then I believe that is where the employer would become responsible. But it's something that we need to put in the provision and detail the process to be involved in that situation. But I don't believe it's something that can't be done. I think it's something that must be done.
Well, this legislation is going to be far-reaching.
So,
It's going to be.
to respond to the gentleman just now, so the thing is that we're not holding the employers responsible for sexual harassment committed by clients. We're giving them the task of creating policy that includes that, because what we will find is if there is one business that is more progressive than another in terms of enacting such a policy that protects workers from clients, the clients that are more likely to do these things will gravitate towards the businesses that won't put these things in place. So the point of putting them in place universally is so that you won't have some that won't do it and some that do it, and then the ones that do it are being punished by the market and the ones that aren't doing it are being rewarded for not doing it. So that's the idea, because as Senator Fraser-Binns was saying, it's responsibility of the employer to create that environment. And first of all, these workers on the front line are making money for these employers. They're there because those employers are making money from them.
Remember that you have in the workplace, you have the employer, and then you might have a supervisor and a manager, and it has to go through. You might have to report to the supervisor report to the manager, and the manager report to the employer. Which one will be liable?
It's not that the employer as an individual is personally responsible, it's that the business is responsible for having a policy.
Yeah, but you have to take somebody before the tribunal.
No, but if I might, Minister, we are going in if I might say, an era that this Act does not, to the best of my knowledge, provide for. Now, if it is that the environment is unfriendly to the employee or provides for that sort of behavior, then under the OCHA Act maybe, or creating a better employment environment. But because if it happens that a client is the one who is harassing the employee, who is the employee going to who is the complaint going to be made against?
That's what I'm saying.
When you go to the sexual harassment tribunal, because it can't be against the employer unless it can be demonstrated that the employer is in
failed
conspiracy.
to implement a policy?
And I'm saying that this act, to the best of my understanding, does not provide for that.
That's the problem. So that is what we're saying. We're saying it doesn't provide for that, and we're asking that amendments be made so that it will
What
provide
you're
for
saying, sexual harassment in the workplace should not just think in terms of the employer and the employee, but the clients and the employee.
Yes.
The employee.
And we think about it in both ways. So my colleague here was just reminding me that another section of our submission addresses harassment of clients by workers as well. So section 2, because what we were just discussing were the points from section 3, but section 2 speaks of sexual harassment by workers of clients. Now we read, so the bill, it doesn't really seem to account for the possibility of private sector businesses, like clients of private sector business being harassed by workers, and this is why this is said. Give me a second, let me find the exact line.
While you're looking for it, Mr. Bailey, I know that that this piece of legislation will not take care of everything. And the employee being harassed by a client, for example, is there any contemplation, any legislation that's being contemplated? That, and even with street, being harassed on the street, is there any kind of legislation being contemplated to address some of the things that will not, or so far have not been addressed in this?
The direct answer to your question, Chair, is not that I'm aware of. But I think the discussion by the members, I think has hit the nail on the head in many respects. Excuse me. From our understanding, the employer is duty bound to provide a safe working environment. And in some of the scenarios presented of the persistent harassment of a particular person, for example, I think those would be grounds to be dealt with under existing legislation like Liberation Justice Disputes Act, because that would constitute not providing safe working environment. In relation to what has been raised, some of what has been raised by Mr. Simpson, in fact, I think would fall under what he has called street harassment, which I think is an appropriate term. The only thing that would fall close to that is work that is currently underway in relation to stalking, which may not cover all of what is being contemplated here. Part of the problem, I think, has been adverted by one of the members, I think Senator Motley, is that there's a culture issue that relates to this, and because there's a wide range and scenarios of activities. So, for example, somebody walking down the street, inappropriate comments, inappropriate touching, they might fall under other things. There was, I think last year, an incident in France captured on video. Somebody in Paris, a woman is walking by a restaurant or something, man makes an inappropriate comment, she does not react kindly to it, so he punches her in the face. And this is in a first world country. So there are lots of issues, and that has to be dealt with under the criminal law. So I'm not sure that this piece of legislation, what it's seeking to do, can address all of that. But there are some other things that we will need to look at and some other things that we need to do. We are aware that there is other types of harassment legislation in other jurisdictions.
Chair.
Thank you, Mr. Bailey. Yes, Senator Morrison.
I must commend us for coming this far with this piece of legislation. I must also say that I think that we are at least 30 years behind in having this legislation. Based on what is being presented here, the arguments, unless we have a national consensus I am worried about the effectiveness of this piece of legislation with all the good intentions, and I know this is something that you feel very strongly about, Minister. But unless we have a population that understands that sexual harassment is something that is extremely serious, we are going to continue having some of the challenges that Mr. Simpson, right, has highlighted. Because in my mind, if someone walks in and harasses, let's say a cashier, and that person walks out, several random individuals may do the same thing. How are we going to control that? In the real world, what will the employer, even with an excellent work environment, it's easy if it's just this one man who is coming in daily and who is harassing her.
Doesn't have to be just a man.
Right.
Can be,
yes, thank you. I don't want to pick a male or a female. Yeah. But then I don't want to have to complete the other letter, because you have male, female, and you have people who identify, right, as other gender. But Minister, I believe that we need to have laws in our country that state very clearly, if you walk into anybody's workplace and harass them, you will have to face the law. We have to get there where outside of this legislation, the nation understands the seriousness of sexual harassment.
Thank you, Senator. I'm going to just take two more comments and we have to go back to Mr. Simpson's presentation. I can no longer limit them to 15 minutes, right?
I was hoping
okay, so I'll take MP Bromberg and then Senator Scott Motley.
Gender balance, go.
Thank you very much, Minister. I believe that as much as this piece of legislation should have been here a long time ago, it means that we have already stepped forward and we cannot be timid in what we do. I think we have to understand the cultural context in which we operate, which is going to make it difficult, and therefore we have to be very clear. So I am hoping that at the end of the day, the issue about harassment, worker-client, is something that will be covered by this bill. If it is sexual harassment, I would hate to be part of a team that says, oh, it is covered by other legislation, let's deal with it there. If this piece of legislation is the one that we're looking to in 2020 to deal with sexual harassment, I believe that issues like those must be a part of it. Senator Morrison spoke about if everyone is on board. Everyone is not going to be on board. So let us accept that. I believe what our responsibility is going to have to be is the kind of public education to bring everyone along.
Thank you. Senator Scott Motley.
I was actually wanting to invite Mr. Bailey to look with me at under Part 2, Clause 3.1, and to tell me how he would interpret the fact that that clause was included. An employer shall make every reasonable effort to ensure that the workers employed by the employer are not sexually harassed in the course of their employment.
Clause 5.
At 5? I didn't look at 5.
Yes,
I'm sorry, I didn't look at Clause 5. Oh, yes. Clause 5 says that an employer shall take immediate and appropriate action to deal with the sexual harassment of a worker of the employer, where the employer becomes aware of the sexual harassment. And that is the context in which I was saying that if somebody keeps on reporting that this customer comes in and is constantly, I use a restaurant context because I think it's easier for us to grasp than the supermarket and the cashier, to make it more easily appreciated. If you have a client who comes in and constantly harasses this hostess, won't the employer be able to, would the employer have a duty under 3 and 5?
And 4.
That would appear to be the case.
The The law requires that the employer shall take every reasonable effort to ensure that the workers employed by the employer are not sexually harassed. If you want an example, I could think that he could go to the client and say, I am sorry, we don't accept this type of behavior at our restaurant, and I'm going to ask you not to continue like that, or I might have to refuse you service when you were, something as simple as that. And then 5 says that is a sort of, might be immediate action which 5 contemplates that an employer would take.
If the employer fails to act.
And if the employer fails to, then under 5.2, then they can be reported to the tribunal. And it seems to me that that's a fairly comprehensive scheme to deal with these concerns.
In fact, what it is also suggesting, Minister, is that if the employer can establish that procedure in their policy, because our union went through a situation at a particular hotel where it was a repeat guest, and that repeat guest continued to come and to harass the staff, and he was harassing a particular staff, and we had to raise the concern. The unfortunate thing is that the staff decided that she was going to leave. So we never know what would happen if, when we created the grievance, what would have happened if he came back. But these are the real life situations that we're going to face. But what 3 and 5 is suggesting is that the employer would be held accountable.
Well, this is really dynamic and very interesting. As legislators, we're really going to have a job to do, making sure we cover all these areas, or as much as we can. Mr. Simpson, please go ahead.
Yes, so watching the interaction now was a little entertaining, if I may use that word, because the first reaction by some members was to say, well, this isn't the scope of this really doesn't need to address this. Then others would say, well, it really does, and then at the end we think it already covers it, which those persons taking that stance would go against what the Mr. Truck was saying with this isn't within the scope of the legislation. I do think it is, because that's why I say it in section 3.3 of our submission, that we thought this was supposed to be a goal of this. It just wasn't clear that, without combing like that, it wasn't clear. Because we did acknowledge that section 4.1a mandates employers to adopt policies concerning the prevention of sexual harassment in the business. And concerning the prevention of sexual harassment in the business is exact wording from the bill. And we did acknowledge that section 4.3b1 states that workers are entitled to an environment that is free of harassment. So we did acknowledge those things. But because it makes no specific reference to client, even though it says in the workplace, we were still worried about the outcome of this when it reaches a body that's supposed to rule over it. Because just now we had, again, 2 different interpretations, with Ms. Fazer-Binns presenting that she agrees, yes, this does cover this, but the opinion by 2 other legislators was that this isn't within the scope, and that us proposing is not something it needed to be proposed. So it wasn't clear to them either, as it wasn't clear to us that this does cover this. I still don't think it's clear. I still think some wording could be done to strengthen the clarity, even though it's supposed to cover for it. Because in their adoption of the policies, in the company's adoptions of the policies, and in the workers' knowledge of their rights, they may not see that as something that they can bring forward.
I think Senator Longmore wishes to make a comment.
Yeah.
Mr. Simpson?
Mr. Simpson, I appreciate your wanting to highlight that issue. But I think that it's something that I'd wanted to highlight from the get-go, and a couple of my colleagues had indicated it. The cultural context in which this legislation is coming into play is very significant. And I think what you're stemming on is almost a governmental responsibility to educate the public as to the ramifications of it. It is not just the client in a workplace, it is the person who is walking on the street. It is the person who is in terms of men who just decide to urinate in a corner in full visibility of a child. There has to be, in terms of the policy implementation, a breakdown to address the different cultural contexts in which these situations will occur. And so I don't think we need to, if we are to single out clients, we are then also going to be not recognizing the importance of other situations. And so we can't spell out every single, in my opinion, every single circumstance. I think what is already in the legislation covers it, but we are speaking to a policy implementation that significantly is going to be impacted on public education.
So when we were discussing this issue at first, as I said at the very start of the presentation, we were concerned with street harassment, but in our meetings came to the conclusion, after multiple hours of meetings, came to the conclusion that legislation couldn't really address street harassment because of the same points you just raised. But we did agree that on the policy front, public education would what would be needed to address that, because if you're going to try to issue fines, we discussed what would happen, what we think would happen if the government tried to say put a fine for random street harassment. But the specific thing we raised isn't random street harassment. It's within the scope of the bill, within what we could say is vague reference, that the bill makes vague reference to, that there should be workplaces created as environment. Well, you say it's covered, but while you say that now, when I just raised it, two other legislators right beside you said that it's not within the scope of the bill. So there's a difference in interpretation even among you. Huh? No, not you. To the other side. They did not interpret the bill as covering that. So you telling me now that it's covered, my reading as well, and I said after the entire interaction ended, was that it's there, so it's alluding to that direction of things, but it's not explicitly clear. And if it was explicitly clear, those two legislators would not have said what they said. But on limited time, we want to go to our other points. So section 2 of our submission was sexual harassment of clients by workers. So this is the other way around now. Not sexual harassment of workers by clients, sexual harassment of clients by workers. So there's a definition of institution in section 2. It speaks to specific types of organizations that I don't think covers private sector businesses in general. And it speaks of specific types of persons who receive care. So in our document, section 2, page 6. Yes, clients by workers. This is the other way around. So section 8.1 and 8.3 both make reference to anyone who is a student, resident, ward, inmate, patient, or member of an institution. And then section 2 of the bill itself now, it doesn't seem to include private sector businesses that don't have a membership system as a type of institution. So it refers to institution. The impression we get, it's talking about places that offer care services or public services. We don't interpret it as private sector. One sec. Page 6, section 2. So this is sexual harassment of clients by workers. So customers and clients of private sector businesses. So you have types of business like banks, insurance companies, remittance services, even furniture stores, courier services, utility companies. You have companies, a wide range of companies that collect personal information, for example, and you could have and do have sexual harassment of clients by workers, taking personal information. This is a story I've heard as often as I've heard of stories of workers being harassed by clients, of persons taking information, messaging that inappropriate hours, and because they just use one phone for everything, they can argue, oh, well, I did this as me, not as an employee of X institution, and so on. But taking persons' personal information that they got through working and contacting persons outside of the workplace for things unrelated to work to the displeasure of the person that they met as a client, or in some cases didn't meet, just saw them from a distance. Oh, you did look cute. I took your number off a form. This is something that happens and something that people complain about.
True. So, Chair, you have some businesses that have a customer information data, and I saw where a teller in a bank got the information, have the information, and then lo and behold, start send messages to the customer. And even more than just messages were being sent. No, not invitation. Graphic pictures was being sent. No. So, he's right. And
There's no question about that.
I believe it was referred somewhere. I'm not sure, but when I glanced through, I saw where the mode of communication, or maybe it's another legislation. But I've seen references where other legislation spoke to the sending these types of messages in terms of harassment.
So 1 second. Where?
You think maybe it's under the data protection?
Oh, another sexual harassment legislation that spoke to that.
Yes.
So this isn't just speaking to say sending. This isn't just, if it's on the data protection, then we'd appreciate that. But this isn't just speaking to sending, say, graphic images, because it may not fall into that. But it can also speak to just making like sexual innuendos. Which
No, man, it can just be that it's unwanted and it's unwarranted, and you don't need to be texting me when I'm supposed to be in my bed sleeping, because it's not business related.
So this is saying that legislation already exists to cover that, to be clear?
I'm not saying that.
Oh,
What
okay.
I'm saying to you is that I understand the context in which
okay.
you are suggesting.
Chair?
Thank you.
That is a means of harassment.
Chair, if I may, I think what the member might
Mr. Bailey,
Yes,
please
what-
comment.
What
Thank
the
you.
member might be remembering is Section 9 of the Cyber Crimes Act, which deals with malicious communication, under which stuff like this could fall, the unwanted communication by a third party.
So the Cybercrime
I-
Act would cover?
Yes, at least in part. And I should also tell the committee that the Cyber Crimes Act is up for review, and that section, in fact, is one of the pivotal sections that is going to have a lot of attention paid to it, to make sure that it is wider and stronger.
So in this case,
Would you suggest then, Mr. B, that when that is being reviewed, it would take some of these scenarios into consideration and kind of link how the legislations work together?
Cybercrimes that we deal with here.
Well, I can't speak for what the committee might do, but this is certainly it's a concern that has come up because of communications of these types, where persons have people's email addresses, telephone numbers, and the like, and send them communications like you have described.
so we should look at that.
But
Are you saying that, Mr. Bailey?
No, I'm saying that there is that section that covers this, at least in part. It is there have been issues in relation to it. It's just one section in the Cyber Crimes Act, and the kind of behavior that we're talking about has covered a wide range of issues. Some things, the tambourine case of recent vintage
that's the one
was an example of that, and it became problematic in relation to the prosecution of that case. So that's one of the impetus for reviewing that particular section to deal properly. I mean, there are wider issues that arise, for example, the issue of revenge porn and other types of behavior like that would fall under that particular provision. So it has to be looked at so we can make that a lot more modern and relevant. So that's as much as I can really say about it.
Well, committee members, we will have to see how we can address this, because having clients' information and using it for sexual harassment is something that we're going to have to look at as well. Mr. Simpson, go ahead.
So, thanks for that.
Chair, before you press on, I should also add that once the Data Protection Act is enacted, that taking somebody's private information would also be a criminal offense and would also make the data controller liable for not protecting it.
So
thank you.
We also don't want to limit what we just said to just the digital communication, because sexual harassment of clients isn't limited to digital communication. Sometimes it's in-person interactions by, say, security guards, even policemen, of sexual harassment by them of, say, the quickest example that comes to my mind is people on campus. But separate from that as well, people on campus, yeah. Separate from that, it's not unimaginable as well that the family member of a patient, whereas the law, this would cover patients at the hospital, a family member of a patient could be the one being sexually harassed, but this wouldn't cover that. And who would they take such a complaint to? It would be up to the individual entities to have policies. So we could expect private sector businesses to have policies. So that's one thing. Even though this is saying we should look at private sector businesses, we could at least expect them to have policies. But with like a public hospital now, if you're not a patient, the hospital doesn't really have an obligation to protect you from sexual harassment if, like, say, you're a visitor. At least from our reading of this, and that's a concern that we want to have. We want this legislation to be comprehensive. If I'm in a hospital and my mother come look for me and she gets sexually harassed, that's not sexual harassment of the patient. Is she considered a client? It would be what? Yes, but then I don't think this just covers sexual harassment of individuals, because that would have to go on to the street harassment type legislation and so on, and yeah, but we wanted to note possible scenarios in workplaces that could take place, because I would still consider them a client. It's just they wouldn't technically be considered a client, because in this definition it's patients, but persons accompanying patients who would also need to visit the hospital aren't covered under this by persons with a duty to care. So we're just identifying gaps for you to consider looking at, to imagine scenarios, and I'm not talking broad street harassment, try to legislate something that addresses every instance of street harassment, but things that we can actually look at trying to control or curb. And then the very last thing, no, there are two more things. I'll try to keep this short. This section 4 in our document, which is on page 9, companies' internal sexual harassment policies, with what I was referring earlier, with differences in interpretation of the legislation, the goals of the legislation just now that took place, I think it would help. Maybe it's already a plan for the Ministry of Labour to do, or the Ministry of Gender. The Section 4 requires companies to have internal policies on sexual harassment. We are also calling for there to be a sort of template created by the government to be offered to companies to help them to align their policies with the goals of the legislation. Because somebody isn't necessarily going to read through and be like, they're not going to necessarily read through, have an immediate comprehension of what the goal of this is, and put something that might not really capture what we want to capture and do what we want to do. So I'm thinking offering templates, especially for small businesses, even though I know that businesses below a certain size wouldn't have to have sexual harassment policies. This template could still be helpful. When you make that crossover from 19 workers to 21 workers and you have to do it, it would still be helpful. And then the last submission The definition of sexual, we're just worried about that. It's really strange how like detailed our law on sexual offenses are. We're concerned about the term sex and sexual because one of the things that's considered sexual harassment is making sexual innuendos, or hinting at sexual intercourse. Would harassment by a male tenant harassment of a male tenant by a male landlord or a male employee by a male employer be covered under the sexual harassment bill? Because it could be argued that what they're inviting them to do isn't sexual by the very legal definition of what sexual is. And here we aren't calling for, right here in this submission, I'm not calling for the Sexual Offences Act and the Offences Against the Person Act to be amended to address this, but for clarification, at least policy-wise, that this does apply to unwanted advances or flirting, unwanted advances against male tenants and employees by male landlords and employers and so on. Just to make sure it's covered, because we don't want there to be a case where, because the law is so pedantic, they say, oh, well, that wasn't sexual. Or female to female, but yeah. So that is really our submission. Oh, wait, my mistake. Colleague here reminded me there's another very actual technical last one. I kept scrolling here before I scroll back, sorry. Section 6 of our submission, page 11, speaks about section 27.1, saying that the tribunal yes, so the tribunal will investigate a complaint if it appears to be well-founded and is not frivolous or vexatious. And the terms frivolous and vexatious there had raised some eyebrows in our meetings. And we're concerned that this may cause legitimate claims to be dismissed. Section 28, in our opinion, already outlines an outcome where the tribunal can find that there is no evidence of sexual harassment, if it is the case. Determining this should not be done without a hearing. So dismissing a claim because it seems to be frivolous without hearing it seems unfair. I think, well, not I, we are proposing that these conditions for hearing a claim in section 27.1 be changed from is not spiteful. Oh, it should be changed to. That's a typo there where it says should be changed from. Should be changed to is not spiteful or malicious rather than is not frivolous or vexatious, or that the conditions be removed entirely. Because removing them entirely or changing them would likely cut down on the number of legitimate claims being dismissed due to potentially changing temperament of the tribunal, as in the different panels and so on. We don't know how the persons on it would be. And section 28 already outlines the possibility of an outcome where the tribunal can find that there is no evidence of sexual harassment, which would be determined during a hearing, we assume, rather than just with dismissing it entirely, unless we misread that. Yeah. So that is our submission. So the summary of it would be, one, we got the clarification on that already, thanks. That's with we had thought that it was the sexual harassment division of the IDT. It's clarified that it's a sovereign tribunal. Second one was to make provisions to protect clients or private sector businesses that don't fit in the existing definition of an institution in the bill from sexual harassment by the workers of those businesses. Or third was to make provisions to protect workers from sexual harassment by clients or persons who are served by the business. 4, clarify whether it's responsibility of the management of each public authority or government to set sexual harassment policies in public sector workplaces. Not so much clarify, that could be reworded, but that's to explain in saying the ministry could put out some templates to help to align the company's policies with the goals of the legislation. And I say templates because you could put different templates as suggestions for different types of businesses as well as a general one. So maybe a general one for any random business would do, but maybe you want to think of a separate one for the entertainment sector. Noting what happens in restaurants and hotels more often than other places. Number 5, clarify whether sexual advances and sexual innuendos are gender specific and ensure that employees and tenants are protected from being preyed on and harassed by employers and landlords of the same sex. And number 6, remove frivolous from the criteria for claims that the court can choose, well, not the court, the tribunal, can choose not to hear and require them to declare or prove a claim is malicious before dismissing it.
Thank you, Mr. Simpson. Thank you for your presentation. I think we can now move on to the final presentation for this afternoon, and that is being done by Mr. Layla, Patrick Layla, Jamaica AIDS Support.
Thank you very much, Madam Chair. Afternoon, members of the committee, other presenters. We at the Jamaica AIDS Support for Life made 13 recommendations in our submissions, which I will attempt to go through as best as possible in the allotted time. I want to get straight into it.
I'm sorry. Mr. Simpson, could you turn your mic off, please?
Oh, I'll just press and it goes up.
Press, yeah. Thank you.
I am supported by Ms. Michael Jackson, Mrs. Gail Williams, and our in-house counsel, Mr. Christopher Goldson. The first point we made in our submission, I allude to the earlier discussion around the word adverse being defined. I think when the Ministry of Labour was presenting, they raised the point of the word adverse being defined. We are recommending that in Section 2, where the bill defines sexual advance, Section 2, Part E, it reads any other physical, gestural, verbal, nonverbal, or visual conduct. We are recommending that the word written be inserted in that so that it is explicitly clear. We know that in the general understanding of the word verbal, it may cover anything oral or written, but if we look at the discussions about what words mean when they are used in legislation, we are recommending that the word written be inserted in Section 2, Part E, where sexual advance is defined, and that will address a lot of the concerns we heard raised earlier. We are recommending that the definition of sexual harassment be broadened to include stalking. It is important to note that stalking is not a substantive offense in either the Sexual Offences Act or the Offences Against a Person Act. It's important to note that this was an observation made by the Joint Select Committee of this House that looked at the 4 pieces of legislation, the sexual offences, offences against a person, child care and protection, and domestic violence, that there is no substantive offence for stalking in any of these pieces of legislation. And we believe that sexual harassment as defined in this bill provides an excellent opportunity for us to close that gap by including stalking in the definition of sexual harassment. Recommendation 3 is to broaden the coverage of the bill to include sexual harassment in the streets. Recommendation 3 in our recommendations may be contrary to most of the utterances I heard earlier in terms of the culture and all those reasons why we think we cannot police harassment in the streets. But I want to suggest that it is not for us to decide that if persons are being violated because it's culturally acceptable, that we should ignore it. I think it is the duty of the legislature to find ways how we can address these concerns that have broad cultural implications. So we are recommending that street harassment be included in the bill. Madam Chairperson, you asked earlier of the representative of the Ministry of Justice if there is any other legislation that contemplated these matters. I think Mr. Maurice Bailey answered, and I'll join him to say there is none that I'm aware of that addresses or contemplate these issues, and this piece of legislation provides an opportunity for us to address the issue of street harassment. The reality is, street harassment is one of the most common forms of harassment worldwide, and we were very much disappointed to see that this legislation as being contemplated was confined to institutions. We think that it provides an excellent opportunity for us to look at street harassment. It is one of the forms of harassment that has had damning effects of many of our citizens. The data out there shows that 68% of harassment that takes place is street harassment. We find persons having to change their route, change their mode of operation, going to a different supermarket each week. We spoke of the supermarkets earlier, simply because they are trying to avoid passing the garage, passing the bar where the guys always hang out, to avoid being harassed. So we think that it would be a missed opportunity. There's always the discussion, everything cannot be addressed in one piece of legislation. But the reality is, we will never address everything, because some things may never have been contemplated while we are looking at the legislation. But the fact that it is raised provides an opportunity for us to address it. Let it be that the things that we did not address are things that were never contemplated, and not that it was raised and we thought we should not have addressed this. Yes, Senator Longmore.
Chair, if I may, I really appreciate you bringing it to this level. And I just said to my colleagues, in terms of when we say streets, are we also acknowledging the need for public transportation? It is a very serious, critical issue. I heard of a scenario where a 15-year-old girl was so constantly harassed on her mode of transport that the mother was in tears trying to figure out how she can get to school safely because of what she was facing on a daily basis. And I think one of the prime situations in our culture is within that mode of situation, whether taxi drivers, whether in bus drivers, whatever, conductors. So just want to make sure that when we are referring to in the streets, we are also referring to public transportation, public spaces, etc., etc.
Thank you very much, Senator Longmore, and I recommend that you read thoroughly point 3 of our recommendations, and it explicitly, because I'm not going through in detail. If you look at 3.2, it speaks specifically to public transportation. So we did contemplate that when we are talking about street harassment. So it's any space outside of these institutions, workspaces, as defined in the current legislation. Yes, public spaces. Recommendation number 4, we are suggesting that we include a specific provision to deal with sexual harassment committed by an outsider against an employee of an institution on the premises. That discussion was going on a lot earlier. My previous presenter raised it a lot. We think that this is something that the legislation has not contemplated, and I'm reiterating it because I think it is important for us to consider persons, and we took it further than just the average customer walking in, but we have a lot of companies that engage third parties that are not under the direct supervision of the company. We have security contracts, janitorial contracts, all of these third parties that frequent the workspace and may harass an employee, or may they themselves be harassed. We think that this is something that we should look at. I remember Minister Chuck earlier asked, what is the employee going to do about this? What is the employer going to do about this? But the bill in its current state addresses the fact that if an employee brings this to the attention of the employer, then it is to be addressed. And then if it is not addressed, that is when the employer would be held liable. But it could not be that the employer is just going to be held liable without any knowledge that the harassment took place. It is trite law that employers have a duty of care to their employees. Recommendation number 5 is to include a specific timeline for the issuing of the policy statement. Section 4 of the bill requires that places a duty on an employer or person in charge of an institution to issue a policy statement. And the section outlines what should be in the statement. This is pretty much putting up something to say sexual harassment is not tolerated here, this is not allowed. But I think it needs to explicitly state a timeline either after the passage of the legislation or after the establishment of a company, if the company comes into effect after the legislation has been passed. So if this legislation should be passed sometimes this year, a company that opens offices in 2021, what time period are they allowed to develop and issue this policy statement? I think the recommendation of my previous presenter to provide templates would help in this regard as it relates to the timeline. We hear a lot of discussions about words and what they mean. And our recommendation number 6, section 5, requires the employer to take immediate and appropriate action. I can speak to a plethora of case law where the judiciary is forced to be deliberating what immediacy and appropriateness as used in legislation means. So we are suggesting that immediate and appropriate must be defined in the legislation. This is a recommendation. It is understood that this leaves it to be, it becomes subjective when, as the employer who becomes aware of the harassment, I had many other pressing matters to attend to, and I dealt with the situation as immediate as it was convenient for me, and that was my immediacy. So we need to have clear definition as to what immediacy and appropriateness means as used in the legislation. We are asking for there to be more explicit terms in the legislation as it relates to gender harassment. Recommendation number 7. I was delighted to hear earlier, Madam Chair, when Senator Morrison spoke and she said a man, and you interrupted to say it doesn't have to be a man. It could also be a woman. Sexual harassment has a power dynamic at its core that constantly reminds historically marginalized groups, such as women, members of the LGBT community, of their vulnerability to harassment. Further, it reinforces the ubiquitous sexual objectification of these groups in everyday life. We believe that the bill needs to be very clear in how it addresses sexual harassment in terms of sexual harassment being sexist, racist, transphobic, homophobic, all of these slurs that's used to attack people or to address people, that definitely amounts to sexual harassment. So we are asking that the committee look with favor at incorporating in the bill this sort of gender harassment and this balance to ensure that any form of harassment towards any group is covered in the bill. I use this opportunity to invite the minister the chair in her capacity as Minister of Culture, Gender, Entertainment and Sport to meet with us to discuss in much more detail this issue of gender as it falls under the portfolio ministry. The recommendation number 8, we suggest that we remove the provision from the bill that requires the harassment to be reported within 12 months. Section 25(2) suggests that it must be reported within 12 months, and where the harassment is a series of events, the 12 months after the last event in the series. But we are recommending that this legislation contemplates the practice in sexual harassment legislation in our country where there is no statute of limitation. we are very much aware of the nuances when it comes to sexual harassment. And the many reasons I could get into, if you read recommendation 8 in our submission, it is outlined there why people may not come forward immediately when they are harassed. And we think saying, if you don't speak up in 12 months, then you are not harassed. We think this is doing an injustice, and it should be deleted from the legislation. Recommendation number 9. The bill in section 10.3 provides for an authorized officer to give direction to a person found to be in breach of section 3 or 4 of the Act to comply with a directive within a specified period. And section 10 subsection 4 prescribes a penalty not exceeding $1 million for companies who are found to be in breach. We are recommending that these penalties be increased. If we are taking sexual harassment seriously, $1 million for some company may be nothing. And it may be just that sexual harassment continues to be perpetrated, and we just pay $1 million. That don't affect our bottom line. So, we are recommending that the penalty be significant. The penalty be much more significant, so that companies are very careful not to be in breach of this provision. Yes, sir? No, I thought the member wanted to say
I was
something.
just saying that in terms of the $1 million fine, I don't think we should use any specific figure, because $1 million might be the entire asset base of some
Of
company.
one, right.
Yeah, so use a percentage of profit or so.
Point taken. I recommend, and that's a recommendation, that's an excellent recommendation in terms of there is a scale. Right. So depending on your size, yes, $1 million may be significant for you. Yeah. But thank you, Mr. Witter.
Thank you, Mr. Witter.
Recommendation number 10 is to include a provision in the bill for persons convicted of sexual harassment to be entered in the sex offenders registry in specific circumstances. I know there will be a lot of questions around this, but we are saying in specific circumstances. We submit that a person who is convicted under this legislation should be recorded as a sex offender if the offense is committed against a person under 16. If the offense is committed by a person in a position of authority over the complainant. If the offense is committed against a person over 60 years of age. And if the offense is committed against a person suffering from a physical or mental infirmity. These are the specific circumstances under which we are recommending. And this is in the spirit of the Child Care and Protection Act and the Sexual Offences Act to provide protection for our children, the elderly, and persons who suffer from mental or physical infirmity. The Joint Select Committee of Parliament that reviewed the Sexual Offences Act and related act made a recommendation for the offense of predatory sexual assault. And this was with the same thinking that we need to, where possible in legislation, provide protection for our children from sexual predators. Recommendation 11, we have concerns about the constitution of the tribunal, and we are recommending that the provision around the constitution of the tribunal be very clear, so that the tribunal is not only properly constituted, but properly resourced. Section 11 provides for the establishment of a sexual harassment tribunal with the power to hear and decide matters. The tribunal members, there must be 12 members. The legislation says 4 attorneys, 4 certified mediators, and 4 other persons are selected by the minister with responsibility for gender upon consultation with the ministers of labor and justice, I think. We submit that the bill clearly mandates that one of the final four, we have 4 attorneys, 4 certified mediators. We are recommending that one of the final 4 be a representative of civil society, of course with the requisite skill set as outlined in the bill. This will not only provide for readily available expertise to be at the disposal of the tribunal, but will also honor the government's commitment to include civil society at the table in matters of national importance. So we are recommending that one of the spaces, as selected by the minister, be reserved for a representative of civil society with the necessary skill set. We are also concerned that the it's important to ensure that the tribunal is properly resourced to do its job. When we reviewed the legislation, the first thing came to mind, we contemplated, why isn't this just left as a matter for the court? Why set up a tribunal specifically? But then we said, okay, a tribunal is going to be set up, but we looked at the examples that we have in the past. We looked at all these commissions of parliament that are set up with these specific responsibilities. I quote INDECOM, the Office of the Children's Advocate, all these bodies that are given these responsibilities, and then at the end of the day, what we hear in the news, the Children's Advocate, I only have 1 investigator. The INDECOM, I only have so much and so more. We can't do what the statute empowers us to do. So we are saying we don't want this to be another tribunal that is empowered to deal with sexual harassment reports, but at the same time, because of limited resources, we just end up having another backlog that is, as we see in our system today.
You don't have to worry about that. That commitment is here. It will be properly resourced. Secretariat will be housed in the Bureau of Gender Affairs, and the tribunal will be properly resourced.
Thank you very much, Minister. I take your word in your capacity as Minister, and I will record and remind you when the time comes of that commitment. It is important that any system set up to administer justice functions expeditiously. As such, besides furnishing the tribunal with the requisite financial and human resources, guidelines must be put in place to ensure its efficient operation. We submit that there should be clear stipulations for the immediate drafting of regulations to complement this act, and the necessary boundaries be clearly articulated in said regulations to ensure that matters heard by the tribunal are heard within a reasonable time frame. We are quite aware that there are nuances specific to each case that may cause delays, but there must be a standard to say that unless there is any peculiar circumstance about this case, matters must be heard and disposed of within a reasonable time. Recommendation number 12, we would like to clarify the jurisdiction of the tribunal where sexual harassment lead to further sexual offenses covered under the Sexual Offences Act. So most of the more serious of the sexual offenses, grievous sexual assault, rape, a lot of these start with harassment. There are persons who have been harassed over a period, and then it eventually leads to rape. We see in 2018, France was prompted to enact this very piece of legislation simply out of street harassment. A woman was harassed on the street. She did not respond favorably to the harasser, and she was attacked. And that is what prompted France to enact immediately sexual harassment legislation. We are contemplating when sexual harassment leads to other serious sexual offenses, and I heard the point raised earlier, will the will there be matters being heard concurrently for sexual harassment before the tribunal and for whatever the more serious sexual offense is before the court? Should the survivor be, we are suggesting that the legislation must contemplate the trauma that the survivor goes through. Will the survivor be required to relive and retell this experience before the tribunal to deal with the sexual harassment piece and before the court to deal with the more serious sexual offense? What contemplation is there for these, either to be subsumed under the courts when this is the case, versus having the survivor having to relive the experience in both spaces? Senator Morrison, I'm sorry she left, she questioned earlier, as I move to recommendation number 13, the effectiveness of this piece of legislation if we do not address public education. And that is what our recommendation number 13 is, that public education around sexual harassment in multiple spaces is a must for this bill to be effective. And this has to be a responsibility of the state. We're public education, and we are talking about for the general public in institutions, in schools. What sort of, we already have challenges in terms of what sort of conversations are being had with our young people in schools around sex and sexual harassment. And how are they in school, an institution as covered by the bill, going to be able to say what just happened to me is sexual harassment? It should not have happened. And this is the system that is in place for me to report that this has happened to me. So we ask that there must be robust public education around the issue of sexual harassment. The submission, the written submission, addressed all these points in much more detail, so we invite committee members to read it in detail. But in conclusion, let me just say that laws are instituted in order to address the ills of the society and to address the mischief that their absence create. If the law is not addressing the mischief or addressing it at the demise of others, then it is the responsibility of the state to fix it. So we must step in, even though there are cultural and other challenges that may hamper the smooth running of the legislation. So in concluding, I repeat our recommendations. We ask that the word written be included in the definition of sexual advance. We ask that the definition of sexual harassment be broadened to include stalking. We ask that the committee look with favor at addressing street harassment in the bill. We ask that a specific provision be included to address harassment committed by an outsider on the premises of an institution or place of work. Include a specific timeline for the issuing of the policy statement as outlined in Section 4. Define immediate and appropriate as used in Section 5, subsection 1. Be more explicit in terms of gender harassment. Remove the provision in the bill that requires the harassment to be reported within 12 months. Increase penalty, and I accede to Member Witter, set a scale for penalties for companies that are in breach. Include a provision for persons found guilty of sexual harassment to be entered in the sex offenders registry in specific circumstances. Ensure the tribunal is properly constituted and resourced with a space for a civil society representative. Clarify the jurisdiction of the tribunal where sexual harassment lead to more serious sexual offenses, and mandate that wide-scale public education around sexual harassment in multiple spaces is carried out. I thank you.
Mr. Layla, thank you for your presentation. Excellent presentation. I think all three presentations were excellent. I'm inviting members. You have questions?
Just something jumped out at me when Mr. Layla took us to the streets in terms of street harassment. And it tells us that the harassment can take place far and wide. And what jumped out at me is, and I'm placing it on the record because I'd want it to go on the matrix, the definition of workplace. We have the definition of worker, but there's no definition of a workplace. And I remember a particular case that I read in South Africa where two co-workers went on a business trip and the female was harassed. As a complainant, there was a challenge because there was no definition in the policy about workplace. And I looked at the ILO recommendation. Workplace refers not only to the specific location where work is being performed, such as an office or factory, but also locations where work-related business may be conducted. And these could include work-related social activities such as reception, organized by the enterprise for the staff or clients, conferences and training sessions, official business travel, business meals, work-related telephone conversation, and work-related communications through electronic media. So I'm suggesting that we incorporate in the definition workplace to protect not only where, for it to include where, and not just the physical workplace that you enter on a daily basis.
Thank you, Senator Gale. MP Brownberg?
Thank you, Minister. As Mr. Layla was speaking, while we were discussing the whole issue, when the matter of street harassment came up, I had not really come down on whether or not it should be specifically addressed, although I figured it was a problem. But as he was speaking, it occurred to me that if we are to deal with sexual harassment, then we have to look at the incidents of sexual harassment and where they take place. And therefore, we could not exclude an area where a majority of sexual harassment takes place. I always thought that if we left street harassment totally out, it would be more difficult for the public education, because you can't allow it in one space and then when you come into another space, you expect individuals to simply now shift their thinking and behave differently in that space. So I want to join in saying that we need to explore how we include street harassment. Well, there's France, and I'm sure there are other jurisdictions from which we can draw example. But again, given our cultural norms, it is important for us to really be bold about it. And forgive me for saying this, Minister, but among our policymakers, although it is a gender-neutral bill and we are clear on the need to ensure that we understand that, among our policymakers, sometimes we have to remember too the thinking that is crafting it, even though there are enough individuals there who support the direction of the bill. And I believe that we would have done ourselves a disservice if we did not also look at street harassment. Sexual harassment.
Yes.
In the street.
Madam Chair, if I may quickly just say to Member Brownberg, in our section where we recommended looking at street harassment, there are examples of jurisdictions where it is, so that can be looked at.
Good. Thank you so much.
Madam Chair,
Yes.
Chairman, I just have two comments on the presentation from Jazz. And the first has to do with the comment number 10 that speaks to the entry of persons found guilty in the sexual offenders registry. And my initial thought is that it's not a proposal that I would readily agree to at this point. I completely understand the intent and the purpose of the registry, but when one considers that sexual harassment, really, the offense is largely based on the experience of the receiving party. It doesn't have anything to do with intent or knowledge. And so I don't know, given that situation without more, that I would readily put particular first-time offender or first-time convicted person in the sexual offenders registry. So that's my first comment. The other thing, and I really seek some clarification, Mr. Layla, at comment number 7, where you spoke about the need to be more explicit in terms of gender harassment. I'm going to ask you to just help me. I don't think I fully understand what exactly you're asking for, because I thought that this bill dealt with the whole gender balance in a real way. But it seems to me that there's something else you're asking for, which, forgive me, but I'm not grasping. So if you could just explain that to me again, then I can share my own view whether I agree.
One of the things, good afternoon, that we understand with sexual harassment, that when verbal or non-verbal actions take place in a discriminatory manner, it's not only based on sexual desires, but the derogatory terms and discriminatory terms that we make against people's sexual orientation and sexual and gender identity. And it's on that basis that if we can think about all the negative language that we use against people who are in the sexual minority groups, whether in the workplace or on the street, whether you put people in a particular department and call it the negative word department, whether we utilize all the negative words we can think of where gender is concerned regarding people's sexual orientation, that is what we're talking about when we mention gender harassment.
Forgive me, Chairman, so you then want to broaden the definition of sexual harassment?
To also include gender harassment when it's not based on sexual desire, but also based on people's sexual orientation, or perceived sexual orientation, rather.
Thank you, Chair. Food for thought. Let me just ask, is this done before? This which you're asking for, can you cite any examples of countries where this is done?
It is the case in the, I'm just looking for my notes, I think the Philippines. I think it is the case in the Philippines, but I can look further and provide that member. But I am sure that in my research, we came across jurisdictions where this was the practice. And I want to add to my colleague, there are numerous terms we could cite where people are constantly harassed on the street, both men and women, because of not because of someone's desire to have sex with them, but because of many other things that amounts to sexual harassment. We had a recommendation earlier for the definition of sexual harassment to be broadened. So we hope that it would be subsumed under that. But on the point you raised...
Just for clarification, are you saying that any kind of harassment would fit under gender harassment? Is that what you're saying?
No.
We did not necessarily want to repeat some of the language that we would have heard in the past, but if we can think of, I'm trying to utilize the most decent I can think of. Butch, for example, in terms of our perception of somebody who presents as masculine, who's physically female. And then if we're talking about how sexual harassment can lead to other grievous sexual assault and so on, the issue of corrective rape, a lot of our clients that we have come across, it started from sexual harassment. Because you identify
how a woman's supposed to be looking. You don't look female enough, and therefore I'm going to be raping you until you look like what a female should be looking like. And we have also come across that in the workplace environment for some of our clients.
And you also have situations where men are harassed by men and women are harassed by
Absolutely.
women.
Wanted to, Senator Binns raised the point about recommendation number 10.
Before we go to 10, though, I'm going to ask, Chairman, if you could...
Please go ahead, Senator.
Before you go to 10, I would really, really love to see how this proposal is treated in other jurisdictions.
Definitely.
So if you could provide us with that for consideration, I'd be grateful.
We will.
Thanks.
Yes. I just wanted to address the issue of recommendation number 10. With the sex offenders registry, we were very careful in saying in very specific and select circumstances, and I think in deliberations this could be looked at as to what circumstances, but it would not be all instances of sexual harassment. We made some recommendations of the circumstances that we think could be contemplated, but we suggest that it be looked at in light of very specific circumstances, and it's not every call that we are suggesting should be considered for this recommendation.
Mr. Bailey, you wanted to make a comment?
Well, I need to start off by saying that unlike what Mr. Layla might have felt, I actually don't speak or represent the Ministry of Justice. I'm from the Legal Reform Department, and notwithstanding our close relationship, I cannot say that I speak for the Ministry of Justice. I should
Thank
remind
you for that.
I should remind the committee, however, conflating that into the committee making its recommendations in relation to predatory sexual assault and also to expand categories in relation to vulnerable persons, which include those that you have noted here. So I'm not sure whether or not you would wish to rethink this part of your submission, but that's for you and the committee.
Yes, Mrs. Brownberg.
Thank you, Minister. So I'm not sure. I mean, I hear the argument about, and I'm at the proposal number 10 in terms of sexual offenses. I believe, however, that we have to look at what it means in terms of sexual harassment when the various categories as outlined are included. And what does that mean? So if we're talking about sexual harassment against a person who's under 16, for example, if we're talking about sexual harassment of an elderly, I won't use the age. I don't know if 60 is the cutoff point, but I mean, whatever that is. But in terms of our seniors, and certainly sexual harassment against a person suffering from a physical or mental infirmity, in particular, let's say in an institution where this person has, whether or not, I know the offense is civil and it's basically an offense, and therefore there are no classes, right, if I understood it right, of offense. But I'm just thinking that that is something for us to look at in terms of how those are treated, And I'm just saying that my initial reaction would be, how are those really treated? Should they just be left with the rest, or is there, or should we be looking at more? I mean, I'll leave it at that.
Thank you. Yes,
Thank
Mr.
you,
Bailey.
Madam Chair. If I may quickly say, I'm glad Mr. Bailey raised the point. We did contemplate that it is indeed a civil offense. We made the recommendation nonetheless because we were also in our discussions thinking, is it that sexual harassment is not seen as a serious offense? Why it was never contemplated to have been a criminal offense as opposed to a civil offense? What is the thinking why we think this is not enough to meet the criminal standard, so it should remain in the civil arena?
Right, but you have other acts that will take care of sexual offenses. Yeah. will take care of sexual harassment. If it is going to be a criminal offense, then it will be covered by the Sexual Offences Act.
Yes, it is covered by the Sexual Offences Act when it becomes a sexual offense. That becomes when it passes just harassment.
Right,
what happens when it stays at just harassment? So it doesn't become rape, grievous sexual assault, sexual touching, none of the offenses covered under, it's just harassment. Isn't that in and of itself enough to meet the criminal standard? That is my question.
That's what you are saying, and I think that's what Mr. Bailey was saying, that the sexual registry was set up specifically to deal with
criminal
sexual,
offense.
yes.
Right, we are
so
aware.
you couldn't use this act to refer somebody to that.
And that point is very much taken, member, but we are now asking, why wasn't this contemplated to have been in the criminal arena as opposed to civil?
Well,
Mr. Bailey?
As far as I'm aware, most harassment legislation in most jurisdictions are like this. They deal with relationships in workplaces and institutions and are designed primarily to enforce better cultural practices and better behavior, and to spare workers and those who are institutions this kind of assault on their dignity, that kind of harassment. And most of them that we are aware of stay in that arena. If it is that what you're advocating is that it be pushed further, then that would have to be, that's a policy decision, not really a legal one, and a decision that would have to be made in relation to that. But most legislation of this nature that we are aware of, and this one is no exception, follows that particular format. That the main idea, and that's been discussed in this committee and raised, is the idea that you need to change culture. And it is done, and in particular institutions, that is done via this. What you're suggesting would be a policy shift.
I would also like to suggest that while I will agree with you that most, and I agree, I'm glad you said most, not all, most legislation in other jurisdictions around this matter remains in the civil arena. I suggest that we contemplate, nothing is wrong with setting the precedents or being the first to deal with it more seriously.
Thank you, Mr. Layla. I think Ms. Grant wants to make a comment.
I just wanted to make the point as it relates to point 13, and it has been something that has been running through our discussion since we started about public education. At our first sitting, we agreed that because of the uniqueness of sexual harassment, that we'd have to do a lot of public education in a number of spaces, and specifically the Bureau of Gender Affairs was tasked to come up with a public education campaign so that the persons could be aware of what it is, what sexual harassment is, what it constitutes, and so forth. So the suggestion is noted, but we were way ahead of you before the suggestion, just to say.
I'm happy for that, thank you. And I also just want to make my final point. We could consider Senator Fraser-Bin's recommendation. If this person continues to be a repeat sexual offender for sexual harassment, maybe it's time to send him over to the criminal arena and get to the registry. But something must be done. You can't just continue to sexual harass and get away with a slap on the wrist because it's a civil matter. Yes.
Thank you, Mr. Lelo. I now realize that the technical persons who are here they're not known by everyone here, and that is why reference sometimes made to individuals as coming from the ministries that they're not really representing. So I'm just going to ask the technical persons who are here to introduce yourselves. starting with the Bureau of Gender Affairs. I noticed they really took the back seat, and we have made reference to you several times. No, here. Use the mic, please.
Christine Kalu, Legal Officer, Legal Reform Department.
Maurice Bailey, Director of Legal Reform.
I'm Carissa Mesado from the Attorney General's Chambers.
Georgette Grant, Legal Officer from the Ministry of Culture, Gender, Entertainment and Sport.
So I just want to say to the presenters here today that we are serious. This is serious business, and we ensure that the technical team is here and good representation across government. And that us gathering here today is not to be taken lightly, as what we do here will affect all Jamaicans from all walks of life. And that your presentations today very much appreciated, and some of your recommendations, if not all, will be taken into consideration during our deliberations. Next, we did agree at the last meeting that we will meet weekly, every Wednesday. I'm hoping that we will be able to. We may not have a long session, but we consider this piece of legislation to be important and urgent. And we did indicate that we wanted to have this legislation tabled and passed during this fiscal year. At this point, it might be a bit ambitious, but no, the end of this last yes, this quarter, this last quarter. But oh yes, so we would not be able to do so, but we will continue to meet so we can do it early in the next fiscal year. Presentations will be made the next time we meet by the Jamaica Household Workers Union and the Women's Empowerment for Change, We Change, the We Change group, and also the Ministry of Tourism. So I want to thank the presenters who came this afternoon and the technical teams and the members of the committee for coming out. And I think at this point we can I'm being reminded that we have to make a decision on the next public notice. But I would say we should go ahead and put a public notice in the newspapers and also use social media so that more organizations will send in their submissions, because we want to have the input from as broad a group as possible, various organizations and individuals. So at this time, I would want to know from members if you would wish for us to meet next week, or we had actually decided that at the last meeting that we would meet every week, and so the slot is available to us. It is for us to decide if we will follow through on that decision, or if we want to. I would recommend that we follow through on that decision. We meet next week when presentations will be made by We Change and the Jamaica Household Workers Union, as well as the Ministry of Tourism. All right, so with your agreement, I think we can Any other business? I think at this point, I can ask for adjournment to be moved. Mr. Whittle, moved by Mr. Whittle, seconded by Senator Fraser-Binns. Just want to thank you all for coming. Thoroughly appreciate your presence here and the presentations made and the interventions made. Thank you, ladies and gentlemen. Meeting is now adjourned. Thank you.
You never put up a fight, no. Paradise Plum. Just know me like we knew we never had to say a word, not a sound. Silence, you baby. You never put up a fight, no. Paradise Plum. You just know me like we knew we never had to say a word, not a sound. Silence. You never put up a fight, no. You never put up a fight, no. Paradise Plum. And keep it locked to PBCJ. This is your girl, Naomi Cowan.